May it please the court. Please. This is not a case or a discussion about the biggest cases necessarily of the year, but just the cases where the Supreme Court decisions have seemed to have themselves changed the law or developed it. It helped probably to follow along in the outlines, but I'm going to try to go through these pretty quickly. The first case is Marco versus Marco, and there we have a case on judicial recusal. A lot of times it's been described that it's discretionary, and the Supreme Court has clarified that now to say, well, it's discretionary for a judge to determine the facts related to application of the judicial canons. But once those facts are determined and it fits, there is no discretion for a judge to recuse themselves. In Johnson versus Miller, it's a case about sanctions and frivolous pleading. The Supreme Court has now made clear that it's not just judged from the beginning when a case is filed, but that the case can become, as a result of facts discovered or developed, frivolous at that point, and a motion for sanctions could have a basis later in the case. In Lienhardt versus Lienhardt, we have kind of a refinement of the summary judgment standard. Sometimes in my practice I've gotten a decision from a judge on a summary judgment motion that tosses out the case for a reason that wasn't necessarily argued by the parties. The Supreme Court has clarified that that is permissible, but the court must give the parties an opportunity to make arguments on that, give them notice, and even develop facts before a court does toss out a case for a reason not argued. Young versus Orey is an evidentiary question when inadmissible evidence is admitted, but then the court later strikes the evidence or instructs the jury to disregard it. Does that necessarily cure the error? And now we have a test for the court to determine whether or not the error has been cured in that type of situation. In Thompson versus the American Peace Hospital, this is another interesting case. We have a lot more trial depositions happening. And in this case, the Supreme Court made clear that when you have a trial deposition and testimony is not objected to at the deposition, it is sufficient if a party later, prior to trial, makes that objection. And the court can then rule on it and exclude evidence based upon that. So you're not necessarily stuck in terms of evidentiary rulings with what happened at your trial deposition. Powell versus Lester is kind of just a confirmation of what Rule 52A now says, that trial courts can put their findings of fact in memorandum decisions. Bailey versus Dooling, we have finally a case on quasi-estoppel, as if we didn't need another estoppel. Velocity Investments just came out, and here I think it's interesting. This caused some debate actually on the listserv, those of you who follow it. We had kind of Lee Schoenbeck on one side and Dean Macer on the other, and both had very good points. But the Supreme Court has resolved this issue, and most issues now it seems to be in favor of trials on the merits. And they held that it was an abuse of discretion for a court not to allow a party to amend its, when a court answered, amend its answers to requests for admissions. So more leeway is given on discovery in favor of resolving things on the merits. The issue of appellate practice, it's now clear, it probably was already, but now very clear that a motion to suppress is not a final order. You can appeal the circuit court. Your appeal or the state's appeal is straight to the Supreme Court. Surgical Institute versus Sorrell, I thought was an interesting case there. The party had a complaint, and certain counts were dismissed on a motion to dismiss, and then they later filed an amended complaint that did not include those dismissed claims. And the Supreme Court held that even though they were not repled in the amended complaint, you could still on appeal from the dismissal of those original claims. Guardianship of Murphy is an important case because it's now, I think, confirmed. This is the first case that confirms that the 3-day mailing requirement does apply to a notice of appeal. So when a notice of entry of judgment, when that's served, that triggers a notice of appeal, you have 30 days. Supreme Court's now confirmed that the 3-day mailing statute does apply to that. So if your notice of entry of judgment was served by mail, you now have 33 days to appeal. I think it's safe to say. It's interesting though, I have seen people start to serve notices of entry of judgment by hand delivery, which I assume is because of this rule, to eliminate the 3 days. The area of torts, negligence, and causes of action. The leaf green test for vicarious liability has been around forever, it seems. Now, instead of that test, that's still there, but we have now a 10-factor test, so vicarious liability briefs got a lot longer this year. A couple of cases in dealing with abuse, the Blue Cow Abbey case and the Catholic Diocese case make clear that the statute of limitations is not going to be extended for entities as opposed to actual perpetrators. I'm going to pronounce this Walter versus Fuchs. I hope that's how it's pronounced. Here, it's kind of an interesting argument, but it's clear that the DUI presumptions regarding blood alcohol content only apply in the criminal context, that they have no application in negligence cases. Rupert versus City of Rapid City, this is probably one of the more significant cases of the year in the area of takings. It makes clear that factual issues are going to be decided by a jury, not a judge. And it also limits attorney's fees, and also appears to, and I'm interested in what other people, how they read it, but it appears to eliminate trespass and negligence claims in the inverse condemnation context. So usually those are kind of tag-along claims in those cases. Those might be gone. In the contracts area, we just had a couple cases, and they both relate to the parallel evidence rule. The Supreme Court has made clear that the parallel evidence rule applies in UCC cases, and that it has no application, though, where fraud and inducement to a contract is alleged. So really, if that's alleged credibly, the evidence regarding the formation of the contract will come in. The insurance context, there were a couple of interesting cases. Pedersen, that has, to me, a potential to be the most significant if there is fraud or misrepresentation related to the policy committed by a co-insurer. You have two people who share the same policy. If one commits fraud, but the other is completely innocent, the Supreme Court has held that the policy is void. So your innocent co-insured could be hurt and lose their insurance coverage because of something they had nothing to do with. But they decided that as a matter of contract. The Wheeler case also makes clear when you have underinsurance coverage exclusions and uninsured motorist coverage exclusions, the statutes are very different, and some exclusions that are perfectly permissible for underinsurance motorist coverage are void as a matter of public policy for uninsured coverage. So take a careful look at your exclusions and which type of coverage you're operating under. I'll skip to family law. We do have a very significant case on the Indian Child Welfare Act. The Supreme Court has joined with the majority of jurisdictions, but I think it was a pretty significant split. But there is a difference between active efforts required to keep the family together under the Indian Child Welfare Act and the reasonable efforts that are required under the state statute to prevent family breakups where the ICWA does not apply. So there is a area of space in between those two standards. And then later then in the interest of SEHE case, applied that and held in that particular case that active efforts were made. Still under family law, under Belfier versus Peterson, there's another case involving grandparents seeking custodial rights, and the Supreme Court has made clear that they don't have to meet their trial burden in order to simply intervene in a case. They'll be allowed to intervene if they have well-pleaded facts, and that's then where the constitutional standard begins to apply when you actually make the decision. So you don't put the cart before the horse. Under workers' comp, Supreme Court has made clear in all agency, actually all administrative law, that notwithstanding what Rule 52A says, that the standard of review for documentary evidence, transcripts, medical records, depositions is going to be de novo, notwithstanding what Rule 52A might say. And lastly, in the criminal area, a few significant decisions. I thought State versus Tillman is a search and seizure case They do Supreme Court made very clear that they're going to parse out different events at different times and for different people. So there might be probable cause for one person on the scene, but not for another. A subpoena, a warrant may cover certain things, but not others. They've done a good job of parsing that out in the Tillman case. We have, of course, a couple death penalty cases that made some law. We hopefully don't have to use too much. The Confrontation Clause case this year is State versus Toohey. There, it's pretty lenient, I would say, definition of the Confrontation Clause, available to testify whether or not you can actually get substantive testimony, appears to meet the standard in most circumstances. State versus Gicht is a significant case. That's a pretty significant change of the law. The Supreme Court has now made clear that for a specific intent crime, an aider and abettor to be charged under an aider and abettor statute, they must share the specific intent of the principal. So it's been unclear, and there have been cases previously that have held that they just had to assist somebody in a crime. Now, an aider and abettor must share the specific intent of the principal in order to be convicted. Then I thought, finally, lastly, several more criminal cases, but the one I thought hard to pick. There wasn't a blockbuster case this year, but my case of the year is probably going to be State versus Amick on the last page. There have been a line of cases where the Supreme Court had said on a traffic stop that once the reason for the stop is dispelled, the search had to immediately end, or the contact had to immediately end. And that had kind of led to some absurd results where a policeman would stop somebody and then see that, well, wait, there's not a problem with the license plate. And under the strict interpretation of previous cases, they kind of had to get in their car and leave without explaining even to the person why they stopped it. The Supreme Court has now cleared that up to the relief of law enforcement. They're not allowed to, even though the reason for the stop is dispelled, they can make contact, even perhaps get a driver's license if that's necessary, and continue it on. But as soon as they've explained what they've done, then they do have to end the search. And then finally, I know this has been a burning issue for a long time, but it's now clear, Smith versus Rustic Home Builders, that non-licensed attorneys are not permitted to appear pro se to represent limited liability companies in legal proceedings. That is the year of the flag.
Once again, thank you everyone for coming out this morning. And if you could just fill out program evaluation that's in the back of your CLE notebook, and maybe just put them in a pile at the back table as you exit. We would appreciate that. And thank you again for coming out this morning to our early bird.